Now I want to kind of do a deeper dive into what is collaborative law. I know it's a fairly new area of the law, and you're one of the few people that I know, quite frankly, who focus a significant part of your practice to this area. So if you can educate us all on what collaborative law is, and the follow up is, tell us about mediation and what are the differences.
Okay. So as you indicated, collaborative is relatively new. It started in around the late 90s. Typically, the collaborative process includes a professional team. And that professional team is working with the parties and helping them come to an agreement that works for them and their family. One of the very unique aspects of the collaborative process is that everyone on the team, all of the professionals and the parties, have to sign up what's called a participation agreement. And that participation agreement basically says that they're going to act respectfully with one another, be completely transparent. So they have to provide, there's no hiding the ball. Everybody has to, give full disclosure of assets and any information that may be important to one of the parties being able to base an agreement on. And the other piece is that if they can't reach an agreement in the collaborative process, they have to hire new counsel to take the case to litigation. So the attorneys that they are working with, the collaborative attorneys, cannot actually do the litigation if they don't reach a resolution.
Okay.
How collaborative is different from mediation? One of those important things is the participation agreement. You don't have that within the mediation process. Often in the mediation process, you may not have all of the professionals working as a team. You may have them kind of in the background, and may have them on the side that you personally, one of the parties may be working with, but they're not all sitting around the table at the same time talking and reaching an agreement.
Is mediation, is it required in the state of Maryland, or is it optional?
So there's kind of two answers to that. If parties start out in litigation, so someone files for a divorce or files for custody, if custody is an issue, most of the time the court will order custody mediation, unless there's, safety reasons, or maybe they've already tried mediation and it simply didn't work. Parties can also choose to do private mediation. I do both court and court order mediations as well as private. So sometimes parties will try private mediation to resolve their disputes without having to go to court, except to have the uncontested hearing.
And the parties, I guess in terms of the cost, they end up splitting the cost when they go that route?
A lot of times.
Mm-hmm. What